Whether you wear a badge or not, if you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report. Hello, everybody. Welcome back. This is going to be a little bit of a long one. This is TCR-23, Audit America, and what cops need to know before the next call. Before we begin, big shout out to Calfia again for the swag, and then obviously the unending support. I appreciate them. Not everything we discuss on this show is use of force, but they have been awesome supporters. They're a wonderful organization, and if you are a cop in California, you most certainly should be a member because there's wonderful training available. As you know, I'm Don, and this is the Conditions Report. If you've already been listening, then you know the show's premise. And if you're new here, well, here's what you need to know. This is a weather forecast for street cops, detectives, and admin. It's what's coming and what's changing in the environment that we work in. And before we go any further, you already know the quick disclaimer. I'm not an attorney, and nothing discussed on this show, especially this episode, is legal advice. I'm not speaking on behalf of any government agency or law enforcement agency, and the views expressed here are those of Forecast Securities Group and myself, and they're an exercise of protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult qualified legal counsel. And again, this podcast is for educational and informational purposes only. We're not here to judge officers involved in the incidences or second guess their decisions with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf. In this episode, we're going to be talking about First Amendment auditing, and it's become a persistent and sometimes confrontational feature of modern law enforcement. Individuals or small groups will deliberately position themselves in public spaces, often near government buildings, to record officers performing their duties, testing the boundaries of open public observation and free speech rights. And when interactions escalate, these encounters frequently result in detention, arrest, and civil lawsuits and alleging violations of the First Amendment. This episode examines the constitutional framework governing public recording of police activity, the practical challenges officers face in real time, and the leadership principles behind navigating these high visibility moments without compromising public safety or constitutional protections. The topic matters because every street level decision can now be broadcast instantly to the entire world, shaping public perception and inviting federal scrutiny and exposing agencies to costly litigation. And it can make you look like an idiot. The constitutional stakes are clear: protecting the public's right to observe and record government officials while preserving the officer's ability to perform lawful duties without undue interference or manufactured conflict. Let's get into the situation brief. On the morning of February 24th, 2020, a man known in the auditing community as part of the Amagansett Press channel walked into the Silverthorne post office in Colorado carrying a camera. He positioned himself inside the public lobby and began recording, calmly and reciting language printed on United States Postal Service Poster 7. That poster, displayed inside virtually every post office facility in the country, set out the rules and regulations governing the conduct on Postal Service property under 39 CFR Section 232.1. Among its provisions, it's a clear statement that photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meeting, except where prohibited by official signs or directions of the security force personnel or other authorized personnel or federal court order. The auditor stayed in the open lobby area. He did not block the service counter. He did not raise his voice, and he did not interfere with customers conducting their business. He simply stood there with his camera running and continued quoting the regulations that appeared to authorize this exact behavior. A postal clerk watched this recording and grew visibly uncomfortable. The clerk told the auditor that the building was private property and ordered him to stop filming and leave immediately. The auditor politely but firmly refused, and he pointed out the Poster 7 itself permitting the activity that he was engaged in, and that he was lawfully present in a space open to the public. When the auditor would not comply with the request, the clerk picked up the phone and called the local police department for a trespassing assist. 2 patrol officers were dispatched to the call, which dispatch framed as a routine trespass investigation. When the officers arrived, they found the auditor still standing in the lobby, camera rolling, and calmly explaining his position to the clerk. The officers listened to the clerk's complaint, observed the scene, and attempted to resolve the matter without escalation. They asked the auditor to step outside the building so they could talk, but he declined, stating that he had the right to remain where he was and he had the right to continue recording. Body cam and auditor's own footage captured the entire exchange, including his repeated reference to being in a public area and quoting the Poster 7 language. The officers found themselves in this position many California cops know too well. They had been sent to a call based on a complaint that something looked wrong, yet the activity they were watching appeared to be protected. No one was being blocked, no customers were being harassed, and no laws against disorderly conduct or obstructing seemed to apply. The only issue was the camera, and the officers ultimately did not place the auditor under arrest, but they did make a demand that he leave the lobby and stop recording, creating the foundation for what would come next. The auditor posted the entire video online, and the clip spread quickly through the auditing circle, with the titles highlighting what they called police overreach and constitutional violations. Within weeks, the auditor threatened a federal civil rights lawsuit alleging that the officers and the town had violated his First Amendment right to record in a space the Postal Service's own regulations appeared to open to photography. Rather than litigate the question of whether the lobby qualified as a limited public forum and whether Poster 7 created a protected right to record, the town chose to settle. In August of 2020, the town paid the auditor $9,500 to resolve the claim and avoid further litigation. This single documented encounter from Colorado mirrors a pattern California officers confront on a regular basis. Auditors test the boundaries at post offices, police stations, and other government buildings by citing things like Poster 7 or invoking public forum doctrine. Clerks and desk personnel, often unfamiliar with the precise regulatory language, treat the encounter as an intrusion and call police for assistance. Officers then arrive to a scene that looks like a trespass on its face, but quickly reveals itself as something more nuanced once the regulations and forum analysis are applied. Auditors stand on public sideways outside headquarters, step into lobbies, quoting the same language. Dispatch sends units to suspicious calls or trespasses, and officers feel the immediate pressure of government employees demanding action while knowing the entire interaction is being live streamed. One wrong order to stop filming or to leave a traditional public forum can later become the centerpiece for a 1983 lawsuit of excessive force. Even when no arrest is made, the settlement or the viral video can irreparably damage the public trust and force agencies to revisit training and policy. The Silverthorne case stands as a concrete example rather than a hypothetical. The auditor was not violent, he was not disruptive, and he remained in an area the public is invited to use and relied on the Postal Service's own guidance. Officers acted in good faith based on the clerk's complaint and their initial assessment of the situation. Yet, the settlement payout acknowledged that the demand to stop recording and leave likely crossed a line into unconstitutional territory. For street cops in California, this story is a clear warning. When you're dispatched to one of these calls, the first and most important task is to separate protected First Amendment activity from an actual crime or criminal conduct. Is the auditor standing on a dedicated public sidewalk or easement? Is he inside a limited public forum like a post office lobby? Has he crossed into a private apron or a restricted area as defined by a case such as Van v. Target Corporation or Van v. Home Depot Incorporated? And does independent probable cause exist for trespass, obstruction, or any other offense? Or is the complaint based solely on the presence of a camera and uncomfortable feelings? The answers to those questions determine whether the encounter ends in a calm conversation or with handcuffs, citations, a lawsuit, or another viral video that paints the department in a negative light. And these incidences are no longer rare outliers. They've become part of the daily environment for patrol officers, especially in jurisdictions with active auditing communities. The facts from Silverthorne show how quickly a simple recording in a public lobby can escalate into a constitutional dispute that costs taxpayers money and force agencies to defend their actions in court. And the record in the case contained no physical blocking or threats. Officers who study these real encounters gain the ability to recognize protected activity, articulate independent probable cause where it exists, and document their decision making in a way that withstands later scrutiny. The current conditions are this: the legal landscape governing the right to film the police and other government officials in a public place rests on well established First Amendment principles, particularly the public forum doctrine. Traditional public forums, such as streets, sidewalks, and parks, receive the highest level of constitutional protection. And in these spaces, the government may impose only reasonable time, place, and manner restrictions that are content neutral and narrowly tailored to serve a significant governmental interest and leave open ample alternative channels for communication. The right to film government officials engaged in their duty flows directly from the public's interest in holding those officials accountable and promoting the free discussion of governmental affairs. This protection applies whether the recording is done with a handheld camera, smartphone, or live streaming device, provided the individual remains lawfully present and does not physically interfere with official duties. There are multiple federal circuit cases that now have recognized some version of this right. And the foundational case remains Glick v. Cunniffe from the First Circuit in 2011, which held that filming the government officials engaged in their duty in a public place is protected First Amendment activity. That principle has been reinforced and refined by more recent decisions that directly address the kinds of encounters officers face every day when they're sent to audit calls. I don't know if I'm saying this right, but in Irazari v. Ihaya, Irazari v. Ihaya, decided by the 10th Circuit in 2022, an auditor was filming a traffic stop where an officer stepped directly in front of the camera to block the view. The court held that the right to film the police performing their duties in public was clearly established in 2019 and denied qualified immunity to the officer. The decision emphasized that the First Amendment protects the dissemination of information about governmental affairs in real time and that physically obstructing a lawful recording crosses a constitutional boundary. In Sharp v. Winterville Police Department from the Fourth Circuit in 2023, it extended that protection to live streaming. A passenger recorded and simultaneously live streamed his own traffic stop over social media. The court ruled that live streaming a police stop constitutes speech protected by the First Amendment because it disseminates information about governmental affairs as the events unfold. This decision is particularly important for street officers because it confirms the act of broadcasting that does not automatically convert protected recording into unprotected interference. The only remaining question in Sharp v. Winterville Police Department was whether a blanket prohibition on live streaming could survive strict scrutiny, and the court signaled strong skepticism towards such policies absent a compelling, narrowly tailored justification tied to officer safety. In 2024, the First Circuit decided Berg v. School Committee of Gloucester. A citizen journalist recorded his interaction with public school officials and immediately published the footage online. The court held that both the recording and the subsequent publication on a matter of public concern enjoyed core First Amendment protection. Officials could not threaten legal action or retaliation simply because someone lawfully obtained and disseminated the video. The ruling underscores that the right does not end when the camera stops rolling. Posting the footage, even in critical light, remains protected speech. Two decisions from early 2025 provide important nuance and practical guidelines for working officers who are dispatched to these calls. In Hoffman v. Delgado, the 11th Circuit Court addressed recording inside police headquarters lobby, a limited public forum. The court upheld a local ordinance restricting recording in certain municipal buildings because the lobby was not a traditional public forum, and the restriction was viewpoint neutral and reasonably related to security and operational needs. Officers may therefore enforce reasonable no recording rules in secure interior government spaces without violating constitutional protections, provided that the rule is not aimed at suppressing the message. This stands in contrast to traditional public forums, such as the sidewalk directly outside the same headquarters, where such a blanket prohibition would likely fail. In Bailey v. Ramos, the Fifth Circuit in January of 2025 addressed auditors who confronted officers in an active crime scene and refused repeated commands to back up. The court granted qualified immunity to the arresting officer because there existed arguable probable cause for an actual physical interference, with police duties not merely for the act of filming. The Fifth Circuit explicitly reaffirmed that right to film the police under the First Amendment, that it's clearly established that the subject is only to reasonable time, place, and manner restriction. The key distinction drawn in Bailey v. Ramos is that every street cop must internalize when they are sent to an audit call. The First Amendment protects the recording itself, but it does not grant a license to physically obstruct, ignore lawful dispersal orders issued for a legitimate safety reason or interference with an ongoing criminal investigation. When dispatch sends you to an audit call, the first and foremost question is always, what is the actual crime? Probable cause for trespass, obstruction, and disorderly conduct must rest on independent facts, not the mere presence of a camera in a place where the public is lawfully allowed to be. The same careful analysis applies when the threat comes from another direction. In some of these encounters, a civilian will attempt to snatch away or forcibly remove auditor's camera equipment while the auditor is lawfully filming in a public place. These incidents occur with some regularity, and particularly in retail areas like parking lots or shopping centers, where bystanders become agitated and decide the camera is too intrusive. When a civilian reaches out and grabs a camera or a stabilizer and uses physical force in an attempt to stop the recording or remove the equipment, sometimes the auditor may respond with pepper spray and claim self-defense. Officers arriving on the scene must be prepared to conduct a careful analysis, because what appears at first glance to be mutual combat may actually be a one-sided criminal act met with the justified resistance. Officers must quickly identify the elements of robbery underneath the penal code. We can look to California, Cal Crim number 1600, which states the crime requires that a defendant took property that was not his own, and that the property was in the possession of another person, that the property was taken from the other person or other person's immediate presence, and that the property was taken against that person's will, and that the defendant used force or fear to take the property and to prevent the person from resisting. And when the defendant used force or fear, he intended to permanently deprive the owner of the property or deprive the owner of its value and enjoyment for any extended period. In the auditor setting, the camera and its recording constitutes personal property, lawfully possessed by the auditor while engaged in a protected First Amendment activity. A civilian who grabs the camera and yanks the stabilizer or physically uses force to stop the recording may satisfy each of these elements, because it is forcibly taking against the auditor's will with the intent to deprive them of the equipment or footage. And that point, the auditor's deployment of pepper spray may constitute a lawful self-defense under Cal Crim 3470, which states defense of personal property under Cal Crim 3476 if he reasonably believed there was an imminent danger of unlawful taking or injury and it used only the force reasonably necessary to prevent it. Officers arriving on scene must articulate the distinction clearly on body camera, determining whether this was a mutual combat or a one party committing a robbery, while the other defended both a constitutional right and personal property. Precise articulation turns a chaotic viral moment into a defensible enforcement action and shields the agency away from civil claims that will inevitably follow missteps. Turning to the post office scenario, U.S. Postal Service Poster 7 and the underlying regulations provide a conditional permission for photography for news purposes in lobbies and other places. The lobby functions as a limited public forum, and in many instances, a non-public forum where reasonable content-neutral rules against disruption remain enforceable. Officers responding to these postal trespass complaints must therefore distinguish between lawful recording permitted under the regulation and actual obstruction or refusal to comply with valid security directives. The Supreme Court has made clear in a case called United States v. Kalkinda that the postal property, including the sidewalks and interiors, can be treated as non public forums, allowing the government broad authority to impose reasonable viewpoint neutral restriction tied to the property's purpose. If the auditor is standing quietly in an open lobby without blocking the service window or impeding customers, the mere act of filming would likely not constitute, in itself, provide any kind of probable cause for arrest. Conversely, if the individual is physically blocking access, raising their voice to the point of disrupting operations, refusing lawful orders to step back for safety reasons, or independent probable cause exists, forum classification is always fact based and specific to that particular event, and the physical appearance alone does not control the level of protection. Now, turning to California, California law adds its own important dimensions to this through several cases, particularly Prune Yard Shopping Center v. Robbins. In Prune Yard, a high school student set up a table in the common courtyard of a privately owned shopping mall in Campbell, specifically to gather signatures on a political petition. The mall owner ordered them to leave and threatened a trespass charge. The California Supreme Court ruled that the state constitution's free speech and petition clauses afforded broader protection than the federal First Amendment, allowing reasonably exercised expressive activity in common areas of large shopping centers, and that the public is invited to use this as a functional equivalent of a traditional public forum. The United States Supreme Court noted that minimal intrusion did not constitute a taking and that reasonable time, place, and manner restrictions could still be imposed. The court established a three-part balancing test California officers must master: the nature and purpose of the primary use of the property, whether it functions more like a public square than strictly a commercial venue, the extent and nature of public invitation to use the property, or whether the owner has invited the public to linger, gather, and socialize, and the compatibility of expressive activity with the property's normal function, whether the speech or recording disrupts the owner's core commercial purpose. And when the answers favor protected peaceful petitioning, filming, or auditing in those common areas, receiving state constitutional safeguards, even when the federal precedent would not compel the same result. Companion cases sharpen this practical line for officers that encounter this stuff daily. In Van v. Target Corporation from California Court of Appeals in 2007, and its companion case, Van v. Home Depot, signature gatherers placed tables immediately outside the entrance doors of individual big box stores inside larger shopping centers. They claimed that Prune Yard Shopping Center v. Robbins gave them absolute right to remain, and the Court of Appeal disagreed. Applying the three-part balancing test from Prune Yard, the court concluded that the apron perimeter areas directly in front of a single retail store lack the characteristics of a public forum, and that those spaces solely were there to intend to direct customers into the store for shopping, and they offer no amenities for gathering or invitation to linger, socialize, and no connection between the expressive activity and the store's commercial purpose. The store maintained that aprons were strictly for merchandise display and customer queuing. Therefore, the private owners retained the right to prohibit activity and enforce trespass when gatherers refused to leave. This distinction gives California officers clear guidance. The Prune Yard case protects expressive activity in the shared courtyard or food court areas of a true mall, but does not extend to the front apron of individual Target or Home Depot stores. The Van v. Target and Van v. Home Depot case decisions provide a bright line that prevents both over-enforcement and under-enforcement on private commercial property. So when dispatch sends you to an audit call at a retail complex, government building, or post office in California, take an extra moment to verify exactly where the public forum ends and private property begins. Use the county assessor's GIS portal available on your MDT or phone. Most California counties provide free public layers showing parcels, easements, rights of way. Confirm the recorded dedication for sidewalk and identify any aprons or setbacks maintained by the store or agency for its own use. If an auditor stands on a dedicated public sidewalk or easement shown on the GIS map, the federal recording right, combined with Prune Yard Shopping Center and common area protections, would likely apply. If they're stepped onto a private apron or entrance of a single store as defined in Van v. Target or Van v. Home Depot, you possess a lawful basis to enforce trespass after a proper warning, documenting that a quick GIS verification on body cam can convert a potential disputed account into a solid articulation of probable cause. It is a simple step that transforms a volatile audit into a clear demonstration of a constitutional discipline. The constitutional principle reaffirmed across these decisions is straightforward and practical for every working officer. The public possesses the protected First Amendment right to observe and record government officials performing their duties in public spaces, and its essential check on governmental power. And the right, however, though, is not unlimited. It yields to a reasonable time, place, and manner restriction in a way that is content neutral and narrowly tailored, and it never overrides actual physical interference with a lawful police or governmental function. Officers who master these distinctions between protected recording and unprotected obstruction or escalation safeguard both the Constitution and their own careers. Departments who train thoroughly on these cases lower the risk of expensive litigation, damaging viral videos, and personal liability for themselves. The weather has shifted and the right to film is clearly established across most of the country. The challenge for street cops is to be able to recognize protected activity and articulate independent probable cause when it exists, document every action on body-worn camera, and avoid unlawful orders and respond decisively when force crosses into felony territory. The leadership navigational aid comes from Justice Luis Brandeis, who once wrote, "Sunshine is said to be the best disinfectant." The simple truth captures the core leadership principle this episode illuminates. Constitutional knowledge is the highest form of command presence. Officers equipped with a clear understanding of the public forum doctrine and the recent appellate case decisions we have examined are far less likely to be drawn into a manufactured confrontation that defines so many of the First Amendment audits. They issue only lawful orders that they can articulate and enforce with independent probable cause or reasonable suspicion. And when it exists, they de escalate situations that are designed to escalate. Leaders who embed this kind of training into department wide scenario based training create an environment where street cops can perform their duties with confidence rather than hesitate for fear of personal liability. This principle connects directly to the facts in our situation brief and the legal framework in the current conditions. Leaders who ensure their people can answer the question, what is the actual real crime in real time, prevent these traps. And the training must move beyond rote memorization of statute. It must include scenario-based exercises that replicate exact types of pressures on calls for service, involving live stream encounters and requiring officers to articulate the forum distinction and independent probable cause requirement for the narrow limits of any dispersal orders and the three-part balancing test from Pruneyard. The bright line distinction from Van v. Target and Van v. Home Depot. And the robbery elements under Penal Code Section 211, Cal Crim number 1600, self-defense rights under Cal Crim 3470 and 3476 when the cameras are snatched. The same constitutional discipline applies when officers themselves become subjects of recording. Principles drawn from Pickering v. Board of Education, Connick v. Myers, Garcetti v. Caballeros remind us that public employees do retain the right to First Amendment rights when speaking on matters of public concern, but those rights are balanced against the government's interest in efficient operation, and officers who know these boundaries are better equipped to respect the public's reciprocal rights to record while maintaining operational control. Now, looking ahead, similar First Amendment audit encounters are likely to increase rather than decrease. The proliferation of live streaming technology, body-worn cameras, and the automatic upload feature and artificial intelligence tools can instantly analyze and distribute footage, and this will intensify the visibility and speed of these confrontations. The evolving legal doctrine may see additional circuits weigh in, and a handful of jurisdictions may attempt to narrowly tailor or buffer zones statutes around sensitive locations, such as active crime scenes or secure government entrances. Institutional pressure from viral videos and public scrutiny will continue to test agency and policies on recording the public and access. In this environment, the most effective departments will be those that treat constitutional training as a continued weather update rather than a one-time briefing. Officers and leaders who rely on careful judgment, discipline, and articulation of probable cause in thoughtful scenario based training will navigate these fronts successfully. The line between authority and liberty remain very thin. Precision and evidence is not an emotion or assumption. It must guide every decision that is made near that line. Obviously, these are super hot topic issues and they make officers look terrible sometimes because officers may be caught off guard and they can be emotionally highly charged. So just remember if you're going to these calls to calm down, to take a second to look at the facts, ignore people's emotions and feelings. If it's in a public place, it's likely protected. Sidewalk, road, open shopping mall. And if that's the case, just understand that there are going to be people that feel uncomfortable with filming. There are going to be people that are expressing their right that other people may not agree with, and that it's not our job to enforce the emotions and feelings of individuals. It's our job to enforce the constitutional framework and the legal framework that we are sworn to uphold. So, as we close, let's remember that the point of this show is not to pass judgment or to revisit decisions with the benefit of hindsight. It's to learn as a team and to improve. We're all leaders, so keep the L&A in the back of your mind. The work is complicated and the environment is demanding, and none of us get it perfect. So stay hungry, stay humble. I'm Don, and this has been the Conditions Report. Be the calm in the storm and clarity in confusion, and always influence the weather.